studio. We're pleased to welcome Christopher Green, a law professor at the Ole Miss Law School. Good to see you again there, Professor.
Good to see you, sir.
All right, so we get this rather bombshell verdict late last week ordering the courts in New York, ordering the former President Donald Trump to pay $355 million in a civil fraud suit, if you will, plus interest, about $100 million of which is already accrued upon handing down the verdict. And then it accrues every day, I believe, until he pays it. He keeps on adding up. And besides that, I believe it also bans him from serving as an officer of any New York corporation for either 2 or 3 years. I can't remember. And I think what the Attorney General... Okay, I think what the Attorney General sought was permanent banning originally, but that's not exactly what Attorney General of New York, Letitia James, got. So, all right, so will you unravel this for us, Professor? Because nobody was hurt here. I mean, that's my first reaction. My lawyers, through all my business experience, would always talk about, well, who had any damages? Anytime there would be just the slightest, little ruckus coming up, were there any damages? Can you prove, especially economic damages? Because other than that, nobody really has a case. Who got hurt here?
Yeah, so you have a lot of authority in the government to deal with, supposedly victimless crimes or victimless civil situations. You're right. Ordinarily, if we're dealing with fraud, you've got to show there's a misrepresentation that somebody relied on, that somebody justifiably relied on producing damages. So if the banks were going to say, hey, we would never have made this loan at that interest rate if we had known, how valuable they really were. Well, they could, they of course would have had a justifiable reliance element. They would have had to show. They would have said, well, look, the facts are, pretty open about, what Mar-a-Lago is being used for, how much value there is. But the banks didn't complain. The reason we have this kind of law, it's a little bit like the reason we have class action lawsuits. So the idea is, well, some people are out there getting victimized by, mistruths, untruths, but they don't. It's not really worth it enough to them to sue. So the idea is, okay, let the Attorney General come in and represent them. But of course, with money, with enough zeros like this, my goodness, the banks, had a huge incentive to be able to collect this if they thought they had been damaged, or if they thought the damage to future relationships with Trump was enough to make it worth their while. But merely saying false things. If you just look through 18 U.S. Code, all the criminal statutes we've got. If you look through Title 97 in Mississippi, there's huge numbers of crimes that relate to lying. So Martha Stewart, she did not go to jail for insider trading. She went to jail for lying to the FBI about insider trading, even though they weren't taken in. She tells some story to them. They didn't believe it. They weren't damaged. It didn't produce any effect. But we've got all these statutes that say, well, if you say something false, later people can come in and say you're going to get dinged for that. One element of this that really is kind of wild is the size of the damage. So, what this hundreds of millions of dollars, this represents the purported disgorgement of profits. So what they did is they said, well, we think you would have had to pay this a much higher interest rate, and if Trump had gotten the same loan, but had a much higher interest rate and paid that off, he wouldn't have made all these profits. But of course, if the banks had come back to him saying, oh, come on, Mar-a-Lago isn't worth that much, you got to pay this way higher interest rates, Trump, he wouldn't have taken out that loan. He would have gone down the street to another bank and said, well, let's see if I can persuade somebody else. The banks thought it was in their interest to get this money off the loan, to have a continuing relationship with Trump. I think that's one of the aspects that seems most vulnerable on appeal, that they can say, look, the world in which we're imagining, in which the banks didn't believe these representations about the value of all these assets, is not a world in which suddenly they make the loan with a way higher interest rate. It probably is a world in which he heads down the street to another bank, but even if they refuse to do it, he just doesn't do the deal at all.
Yeah.
So the size of damages, the size of the disgorgement remedy. Again, it's not really damages to the state, but the size of the disgorgement remedy is definitely an issue. And conceivably, you could see the U.S. Supreme Court having some kind of review of the federal issue of the excessive. If this is deemed to be a fine, which it sort of is, it's something the AG is seeking on behalf of the public. You could definitely say it's excessive because, it's just the way that they're calculating damages is it strikes me as pretty implausible. I haven't been paying attention to the way they did the trial and whether his lawyers didn't jump up at the right time and say, whoa, this whole differential of interest rates isn't the way to do damages. So I don't know if they may have waived that. His lawyers have not looked like maybe the best lawyers in other respects, but it seems like there's certainly some grounds for appeal in the New York courts, the New York Court of Appeals, and conceivably even to the U.S. Supreme Court.
But this money is going to be paid to the state of New York, correct? So, New York,
So you think,
how
oh my
do they
goodness.
How do they have standing to receive $450 million? I mean, do they have something they point to that said, we would have gotten $450 million more if Mr. Trump had valued his assets in a way that we believe is more accurate?
Right. So the state, if you think, if they had, if the banks had demanded, higher interest rates, the banks are the ones that would have gotten
right.
That.
Exactly.
But this is just generally how it is with criminal law. If you've got a crime, the state is allowed to come in and assert just the interests of the public. So the story they're telling is, it's not about the banks. It's about all these other people who had to pay higher interest rates, but they didn't have Trump's relationships with the banks. But the thing is, continuing relationships with business people is itself valuable. And the banks, if you've got somebody who's got a $1 billion, well, obviously they're going to be able to put together deals that other people can't. So it seems kind of wild. Fundamentally, I think the thing that's so weird is the mismatch between the rationale for these laws, which is the AG steps in for the little guy who's not going to be suing on his behalf. The fact that the AG is stepping in purportedly on behalf of the most financially sophisticated entities in the world, banks in New York.
Right, Deutsche Bank,
and saying, they need the special help of the Attorney General. There are, in fact, people who do need the special help of the government to come in and litigate things that they can't afford to. But the New York financial sector, they're just absolutely last on the people who need a helping hand from the government to make these lawsuits.
Center of the financial universe, honestly. In about 4 blocks up in Manhattan when you think about it. So are these laws, similar laws, also in place in other states, such as Mississippi? Could the state of Mississippi Attorney General just decide to up and sue a business or a business person because they felt like they falsified the value of their assets?
Yeah, if you look at, if you look at just consumer protection statutes, you have these civil fraud rules. I think every single state has one. I was looking around. There's if you look at a 50-state survey, they got somewhat different things about exactly what kind of scienter requirements, so how much intent you have to have before you're subject to them, how much remedies you can get, whether private people can sue under these and get this disgorgement. But really, this is a feature of our system where you have a huge amount of attorney general and really the DAs as well, huge amount of discretion, and they very rarely have to explain themselves. About the only people that they ever have to explain themselves to are their immediate superiors. So your ADAs have to explain themselves to the DAs, the local DAs. even in our system, it's very, very decentralized. The attorney general can't even demand, except in unusual circumstances, I can't even demand an explanation from the DA about why they're going after somebody. So I look at it and I think this is an exemplar of the kind of phenomenon that faces really every criminal defendant. They're subject to the DA coming after them. We have these statutes that are way broader than they need to be.
Professor, I'm sorry, we're up against a break. If you can hang around, we can continue this on the other side of the break. Can you hang with us?
Oh, sure, a little bit.
Yeah, we got Professor Christopher Green. We're coming right back in the Element Wealth studio. We're visiting with Ole Miss Law Professor Christopher Green. So, Professor, does this legal term arbitrary and capricious apply in this situation where, let's just say, a politically zealous attorney general targets an individual and says, "Oh, let's find something here," and we found it. We are going to just assert that this individual that we don't particularly like has inflated their assets, and gee, look here, there's a statute that we can invoke to throw them into court and find them guilty, and then cause them to pay a bunch of money. I mean, that's what it looks like, Professor, to the average person here.
The current rules. If you're trying to show a problem about selective prosecution, you got to show that it's based on some protected class. So there's no general right to non-arbitrary prosecution unless you can show it's based on race, based on religion, based on politics. I mean, Trump could, certainly, in a world where he had completely given up his political ambitions. It's hard to say that, hard to see why he would be having the New York people come after him, but that's extraordinarily hard to prove. But actually, arbitrary and capricious, abuse of discretion. We have these rules for out of control agencies that we apply. And that's the standard, arbitrary and capricious. The first big case was the direction of I-40. So I-40. It was just going across Tennessee and was cutting off the Memphis Zoo from the rest of Overton Park. So you had these people who came in and said, we are a group, Citizens to Preserve Overton Park. So this is in 1971, this is the first big case on what it means to be arbitrary and capricious under the Administrative Procedure Act. And they say, you can't just say, well, we want the road to be straight. That's not enough of an explanation. You got to give an explanation why it's, why the transportation benefits are better than, the cost that you're imposing on Memphis. And then actually the other end of I-40, over at the Biltmore, they initially were planning exactly the same thing, I-40 like going right past the house. So they moved I-40 a little bit, so it's kind of on the corner of the Biltmore estate. Anyways, the same thing in Memphis. So one proposal that I've pushed for years is saying, well, prosecutors should be subject to the same kind of question. If you're doing something that in fact imposes a cost on somebody and you don't have any explanation, so the question, would this prosecution, would this action by the Attorney General have happened if it was John Doe, rather than Donald Trump? I think prima facie, the way that the Attorney General has talked about Trump suggests, well, you need some kind of explanation. But as a general matter, the prosecutors don't have to keep records about when they consider prosecutions. Once in a while, you'll see explanations of why they don't prosecute people. So with the vice president and his documents, there is this explanation, but that's really the exception. Very, very rarely do prosecutors ever have to say why they're not prosecuting somebody, and the police don't have to explain why they're not investigating somebody. So you think all the non-investigation decisions that our government makes, they never explain themselves. They never keep data on any of this. If they had a requirement to explain themselves, that would produce an incentive that would force them to keep data and force the enforcement of law to be much more regular. And I think this would be a huge boon for the rule of law. If you look at prosecutors and you say they look like an out of control agency, make them to be subject to the same rules we subject to the EPA to. If they come up with a rule, it can't be arbitrary and capricious, which means they have to have an adequate explanation to show that this is reasoned decision making and it's going to get reviewed by other people than just the prosecutors.
All right, we got a couple of minutes left.
We're reasoning, but it's just our reason.
You've persuaded me, given that such laws exist across the country, that it's unlikely if this thing gets appealed all the way up to the U.S. Supreme Court that they find the law unconstitutional. So what's the likely path and outcome, in your opinion, here at this point?
I mean, I think there's certainly going to be an appeal to the New York Court of Appeals, and the measure of damages is really seems it seems like this disgorgement is just way high. It's stipulating that you're going to have exactly the same deals, but the only difference is going to be the interest rate. I mean, it's just kind of classic, not paying attention to how people are going to modify their arrangements in response to a different rule.
Before we go, what's going to happen?
Yeah.
You think it'll make it to the U.S. Supreme Court eventually? Got about 30 seconds.
I think if Trump loses the Court of Appeals, he'll certainly have a cert petition on excessive fines, and I'd probably bet against them granting it, but it's not inconceivable.
Man, well, we'll keep watching it. We always appreciate your insight and your expertise in this subject matter. Law professor Christopher Green from the Ole Miss Law School. Thank you, sir. We'll talk to you soon.
Always great to see you. Take care.
We're coming right back, folks. We got Fox News SuperTalk News up next, a whole hour.